Hi, everybody. Thanks again for attending our ninth webinar, the Business Estate Planning and Asset Protection. Of course, one of the least most planned for things because, of course, everybody's just busy operating their business and they don't tend to think about it. So again, I want to thank Matt Trotta for coming from Field Law and also my fabulous partner, Kelly Taylor from the Tower Group as well. We obviously deal as a team when it comes to doing this business planning with Field Law for a lot of our clients' businesses. So let's get started.
So generally, one of the important things when we're doing estate planning is to not just think about the personal aspect of succession, because it goes beyond that for a lot of people, and one should always be thinking about their business. Succession is inevitable, and there's always going to be that event, whether it's planned or unplanned. This is something that should be considered whether or not you're in your 20s and 30s, or if you're in your 60s, 70s, 80s, or 90s. There's common planned exits that we would consider would be, a sale, retirement, succession to a family member, succession to a protege, employee, or a partner. But the more important one that often gets missed is the unplanned exits, because these are the ones that catch you off guard, and these are the ones that have the greater financial risk. This would be sudden passing, sudden incapacity, personal issues between partners, shareholder disputes, issues with employees. This could be a competitive issue, a change in the nature of that business in a radical way. So this doesn't have to be overly complex, but it should grow with the life cycle of the business and should consider, the most reasonably foreseeable issues, or issues that, if occurred, would be a substantial damage to the corporate structure, to your well-being. When you're doing this planning, it should be part and parcel with your personal planning. Can't really do one without the other. You can't have, an idea of what happens with your shares if you don't have a proper will, but at the same time, your proper will still can't direct the corporation. A corporation is a third or a separate entity. So for that, you want to have proper governance. That might be a unanimous shareholders agreement. In cases of a single shareholder, it's a unanimous shareholder declaration. You might have bylaws that cover some of these events that are specialized based on the nature of your business. And it may just be in how your business is structured to maximize productivity, to maximize efficiency, to reduce risk exposure, and to reduce issues upon any of these unforeseen events or foreseeable events like that. When planning is done properly, it does result in tax savings, with the caveat to that tax laws change, and so it's important to be vigilant. It's important to look at it. Structures that made a ton of sense 10, 15 years ago can be very problematic now for certain families, depending on their situation. Reasonable planning is very useful to prevent issues in business continuity and to prevent litigation, because once we're in litigation, once we're in arbitration, we're dealing with several different issues at once. We're not just dealing with corporate governance laws and estates laws, we're dealing with family law. We may be dealing with issues of shareholder oppression. We may be dealing with a bunch of different issues. And what makes all of these very difficult is once we're in that arena, we're now in a very subjective outcome. It may not go the way we want. We lose control of that situation. And when we lose control of that situation, we pay an awful lot of money to try to advocate for what our view of that is.
When, like you mentioned, Pam, a lot of this can be often overlooked, or it's easy to not know that it's critical and necessary until it actually is. But an exit is inevitable, right? Your departure from the business is only a matter of time, and what our goal is to make it planned and on your terms and at your choice. So once in a while, we have to move from working in the business to working on the business. It's almost as if your business is a vehicle. Once in a while, we need that pit stop. If we've got a racetrack and everything is frenzied activity and fast pace, once in a while we have to intentionally slow things down. We can lead at least an annual meeting and help you cumulatively address some of these topics year over year.
And that might change over time, because you're finding, like, as even with COVID, a lot of people have had a real sharp unplanned exit all of a sudden, but especially those who haven't, you're starting to see litigation even ramping up for a lot of these business owners on the fact that now you're responsible. They're saying, what is your legal liability and responsibility for your customers? If your customers or your clients get sick, what is your legal responsibility to them? Also, what's your legal responsibility to anyone else in your office getting sick? And are you now going to be dealing with barrages of litigation or things like that, as well as a lot of people have had to lay people off and are getting massive lawsuits on the fact that they've laid them off, or if someone's in their 60s and they were going to stay around for 3 more years and they wanted a retirement. We even have a colleague of ours in a $250,000 plus lawsuit, and one that's up to $2 million because they thought that they were going to get a full retirement and then they were laid off, even though he meant to do it for COVID. They're seeing it as, well, I'm getting too old. If this ends up being 3 years from now and I can't come back, it's a huge risk. So all of a sudden it's like, how does that affect your business when you could be facing a $2 million lawsuit that you don't have that cash in your company, which is, it's scary for a lot of businesses right now, and things are changing on how this, what's happening with this.
All right, let's move on to that next slide. So unanimous shareholders agreements. So really this is the rules for how we get along if there's multiple people in that company. So it is especially useful if at some point in the future people are not getting along. But I think the more that we can prepare and be organized in advance of having the document put to legal form, the better. That'll save yourself time and hassle, legal fees, and just be more organized as a team. And we can help you kind of prepare the background questions and content to try to get organized. And then, you know, it absolutely should be formalized through a proper legal associate and field law, and Matt as well, specialize in this area.
And I think the important thing to think about, we often say to a lot of our business owners, is that if they kind of, you know, don't always have time to do this, and they're like, I don't have time, or they're certainly buying out a business and they haven't done their own USA for the shares that they're holding now, is that, does your business actually, like if you had a partner, does your partner actually want to continue on the business with your spouse? Because that's a big one that actually does happen. Should something happen and that partner may want to buy out the spouse, but the spouse might say, no, you know what, I want to stay. And you're in a very stuck mode at that point where big lawyers are hired and litigation starts, and those numbers can be relatively large. So, you know, Matt, you can tell us more about kind of what this USA should contain.
So that's a really good point. You know, one thing when people think about unanimous shareholders agreements is they tend to think these are designed for large corporations with lots of shareholders, but these are really effective in owner-managed businesses and really effective as an estate tool because of some of the features that these documents have that allow you know, to do really effective succession planning without really getting into the whole estate law and family law aspects of it. So good example of what was mentioned before is, do we really want the surviving spouses to be shareholders upon the death of the primary shareholder, if that's, you know, the brothers or sisters that run the company, or if that's father and son, mother and daughter, whatever that may be. What we can do with the USA is we can set conditions. So the shares enter the estate and the value of those shares go to the beneficiaries, but the USA can determine, do you get the shares in kind or do we force a redemption? And on what terms is that redemption for? Or do the other shareholders have a right to buy you out? And if they do, how long do they have to be able to make that decision? Can you still vote during those times? Situations like that. Or if we have a situation where we say, you know what, I want my children to have this company at the end of the day. So your will is nice and simple and says shares of this company or its successor to my children in equal shares. Then the USA gets to snap into action and say, okay, you need to have these many votes to be able to do certain things within the corporation. That might be changing the business of the corporation, the amount of financial debt or purchases or significant outlays, they may have to be limited so everybody works together. Is that a majority? Is that unanimous? Is that 50% plus one? Depends on the family. Most importantly, what happens when and if the kids don't get along? We have what's called a shotgun clause, as in two shareholders enter, one leaves. One makes an offer that says you either buy me out or I buy your shares at X price. Very effective way to deal with a dispute. At the same time, none of this is foolproof, but it always has a layer of protection. And with that, what happens with confidential information, client lists, goodwill that's been built up, inventory? Is there, maybe there's a provision that dictates how that goes, what your obligations are, what your limits on competition and solicitation are. Can you set up a rival business down the street? Maybe you can, depending on what the company is and what the type of operation is. For something like medicine, it might be against public policy to, prevent somebody from being able to do that for any period of time. And these are things that USAs can speak to that your other estate documents really can't. Where this can also be very handy is if you have an event of incapacity, or incapacity as well, but insolvency was the word I was looking for. Insolvency or a divorce or an event where we now have a creditor entering the fray. Instead of them having, access to the shares and what's the terms and conditions, what's the corporation's option, the USA can have very clearly stated requirements to say, if you have an event of insolvency, if you have a termination event or withdrawal event, here's what happens. So in a situation like insolvency, it may be you're bought out at X% of the fair market value of the corporation, and it's payable over a period of time. That's what your creditor receives. They don't receive the shares, so we don't have to deal with that situation. Important thing to bear in mind there is we can't just say you get it at 10% because that might be seen as a fraudulent preference or some sort of offside transaction between non-arm's length persons. So we have to be reasonable on that, but we can set it up in a way that it at least creates certainty. Same with a divorce. If something happens, you don't necessarily want the shares themselves to be subject to division. It may be the proceeds of those shares. It may be upon a judgment, the divorce settlement is that you get the proceeds. It may be a separation. It may be if you're living separate and apart for more than 90 days. If you start making overtures towards a divorce, even if you're not fully divorced yet, you're still in the infancy of separation, the corporation may want to be able to cut bait from those shareholders and just not be part of that problem. And so being able to have that plan in advance gives a lot more flexibility if these things happen in the future.
And it's always good to discuss those values and discuss all of that with clients around the table. We often say it's really hard when you're coming into a lawyer's office unplanned and you guys start arguing about that, no offense to Matt, but the bill gets more expensive. So, that's these things you want to sit down and actually really discuss is like, what happens if you get divorced? Do you want that supposed to be fighting over the shares in the business to be held up for it? Because that's essentially what happens. And, it costs a lot of money to then deal with it. So it's like, we want to try to plan for all of these things and say, what do you want to see happen? How do you want to see it happen? What are the values around all of this?
Yeah, and you're not on your own. Like that's what we do is we can help coordinate that and help you understand the right questions to start to answer, to document what you choose, to kind of give you some suggestions on what might be a common direction most people use. So it's a process, but it's pretty critical. It comes along. It's one of the key requirements really that comes along with the responsibility of owning a company, especially if there's shareholders involved, like multiple people. Pretty awesome. So let's move on.
So here's the key situation when we're thinking about planning ahead. Building up wealth is a very difficult long-term process, but it's very easy for it to be frittered away. It's very easy for an event to come up. This can especially be magnified if you've been extra successful. That might make you a larger target if there's a potential litigation between one of several people. And I think Pam has a great case study that she'll discuss in a second here. But a really important thing to know, and the really important takeaway, is that once you know who your creditor is, it's too late to plan ahead. Anything we do at that point in time can be challenged, often successfully, because you are attempting to defray the rights of a known creditor. So once you know, once they're more than a whisper on the horizon, it's too late, and that's why you have to plan ahead. And you know, it's never too early in the business cycle to consider success. It's never too early in the business cycle to consider a problem. And this applies to your personal life as well. It's never too early to think, you know, my children may get married and get divorced, so we should plan ahead on that, because once that child knows who their creditor is, spouse one or spouse two, who knows, it's too late to, you know, to play around and try to protect from this wealth eroding event. And, you know, many of these events are unpredictable and they don't come with clear warning. A great example of that is this COVID pandemic. It came without clear warning. You know, it was not fully predictable, and the outcome requires a change in the way that we do business and the way that we plan. But what's important to note is that fixing an issue is always going to be more expensive than good planning. Even expensive planning and time-consuming planning, the bigger the operation, the bigger the issues can be, and the more expensive those issues can be. And so it's something to kind of weigh when you're going through this, is what's the cost of inaction? It may be zero today, but what might it be tomorrow?
Yeah, Matt, I would agree with all of that. Like, you know, I think this this whole work from home scenario that we're all facing has tested people's business continuity plans. And if there wasn't a documented business continuity plan, you know, we might be failing the test there. So then, you know, it's an interesting conversation where it's like, what's the next major problem to occur or disruption in our business, and how can we be more prepared? Again, we can help coordinate that and plan for that. I think one of the examples is Second Cup, for example. There's, you know, a book written on that. Like, there's many stories of things going wrong in this scenario, where just like the last slide where you were suggesting the shotgun clause, things can be, there can be unintended consequences to some of the legal documents that are established if you don't clearly understand it. And if one of the partners has more wealth or more money than another, it can be easy to take advantage of that scenario where the offer is crisscrossing back in that situation, where the buyout can occur to the disadvantage of one and to the advantage of the other. So some unanimous shareholders agreements don't have a shotgun clause, and they have other buyout provisions there. But that Second Cup story is, you know, two good friends that are no longer speaking, and kind of like a really stark, drastic separation there, where a shotgun clause was used, and one person is still, you know, really upset and bitter about how that played out, where they didn't realize.
His name is Frank O'Day, and it's funny because, like, Frank O'Day, for example, has gone worldwide actually telling people his story, and I love his story because, of course, he came from Skid Row and ended up back on the streets. So what had happened is they were two kids kind of off the streets that kind of decided they'd had enough of life, and one by the name of Culligan, you might recognize that name. But they had started Second Cup. They were the ones who actually started it. They expanded it. They did everything with it. I can kind of tell the story about that a little bit. And that's what Kelly was started talking about there. So what had happened is he actually tells the story about, you know, truly there was another guy that was a black swan that wanted to come on board with Culligan, and they didn't know anything about starting a business. They just started the business, they kept running the business, and then finally this black swan, who was a lawyer, who had said, hey, let's get all these things in place, we're going to do a shotgun clause. And he basically offered Frank O'Day a bunch of money and said, either you buy me out for this, or I'm going into business with this lawyer, and I am now going to require this payment from you. If you can't buy me out, you have 30 days to make a decision. Of course, Frank O'Day admittedly said, hey, this is my first business I've ever had. It was kind of fun. He was out spending all kinds of money. So he said, I came from the streets. I spent a ton of money. I just blew it all, and I was having a great lifestyle and going out everywhere. I was going away everywhere. And he said, I've never had this life to live before. And then all of a sudden, this other guy had been saving and saved everything. So he had the deep pockets to say, I can pay that money. And if you can't, because he knew that Frank was blowing it all, he ended up buying out the shares because he said, you have 30 days. He couldn't buy out the shares. He couldn't get bank financing. He went to the banks, and the banks are like, are you kidding me? You came from the street, and you might have this great business, but this business isn't worth this if you guys aren't partners anymore. No one stood behind him, but the other guy also had the lawyer behind him with a lot of cash too. And he lost the business, ended up on the street, ended up for a long time on the street till finally he went, this is enough. I've got to get back on my feet. Since that time, he's now started, he works with UNICEF quite closely. He does the Night of 1,000 dinners where he supports the world charity organizations, actually started Sick Kids as well, and Street Kids, where he supports street kids. And he tells his story because he said, they were just people that had started on their own, didn't know much about business, and then he kind of got screwed because they weren't really spending time on the business. They were just running it and using all their cash. So I think, it's always a great story. He wrote a book, like Kelly was saying. So if any of you guys want to look that up, again, his name's Frank O'Day. And I think it's called From Skid Row is his book, because he talks about the second cup experience from Skid Row. So, that's a pretty sad story, because once it all came worth millions of dollars, and then, Culligan not soon after actually sold the business for billions later, and it's turned over hands much since then. And of course, he then started Culligan. So, it's always an interesting story, and he is, like Kelly was saying, quite bitter. The other story that we kind of knew about personally in Calgary, and of course, this is one my family knew well, and a lot of people in Calgary, it's quite the famous story in Calgary, because there was a company called Frackmaster. They used to do fracking, and they used to be the company that did fracking in Calgary, in Alberta, for oil and gas. And the husband, back in the time, it was fairly trendy for a lot of these oil boys to have girlfriends. And this fellow had a family with this girlfriend overseas, shipped her overseas, and was going to visit her quite often as part of his business of drumming up business overseas. And the family here, who lived in Willow Park, which, we grew up in Bonavista, so it was fairly close, and the whole scenario for the South Calgary, everyone knew about it. And the boys were all of age and all knew what was happening with Dad. And of course, Dad didn't do a lot of planning around everything, had the boys as voting shareholders on the company. So the boys got together and declared Dad insane, and said, Dad's got this family. He can't run this business because he's barely here. We're here. We're voting Dad out. We are getting a big lawyer, which they got one of the top lawyers in Calgary, one of the top litigation lawyers, and said, we're selling the company. And of course, they sold it to a German financier who has one of the biggest houses in Pump Hill. If you've ever seen the biggest house in Pump Hill, that's on the one corner. Everyone, he tends to be in Calgary a couple months at most a year, but he always ran the most famous Christmas parties there. So if you were anybody, you'd get invited to this Christmas party. So everyone used to vie for getting invited to this Christmas party 10, 20 years ago. And you'd get invited to this beautiful home that's worth so much money in Pump Hill. It was ridiculous. But they had sold it to this German financier out from Dad altogether. So that's the importance of planning ahead, as you can kind of see it. Pretty devastating for everybody, but they got even.
Fixing an issue is always more expensive than the initial planning.
Yep.
All right.
Oh,
Let's
absolutely.
move to the next slide there.
So when we talk about wealth eroding events, we tend to look at it as what are the low potential of permanent loss and the high potential of permanent loss. And mileage may vary on many of these things, but typically You look at things like market corrections, death, property damage, insured injury liability. There will be a loss. To the extent how much. I mean, with death, we've got tax, and how much more tax is coming may determine whether or not this one's low, medium, or high. But the ones we really focus on when we're thinking about wealth preservation planning tend to be these high potential events. Things like estate disputes, having children that, maybe don't sell the corporation out from under dad, but take the proceeds of that and spend every single dime, and turn wealth into debt and completely undo all of the benefit that the prior generation did. A big one that's often overlooked is aggressive and avoidance-based tax planning. And part of this is also aggressive and avoidance-based tax compliance. So a good example of this is a situation where somebody goes into an unduly aggressive tax plan that isn't fully thought through and doesn't realize and appreciate the consequences of it. A good example of this is there were a bunch of tax shelter tax plans throughout the 90s and early 2000s where people would invest in these shelter projects and really try to capitalize on these losses. And then when the losses didn't materialize, there was a massive tax bill. And when you have a tax bill, there's a massive amount of interest and penalties that come with it. And these can be ticking time bombs, and people may not realize it, but the cost of it can be significant to a family, not just the payment of tax, interest, and fees, but the cost of paying tax litigators to try to fix it and try to mitigate the damage, as well as tax accountants to try to refile and readdress this. The same thing with a lack of compliance. If you don't file your taxes and there's a tax amount due, the government will eventually notice, and this will fall on your executor at the very least. They then take your liability and run with it indefinitely. Filing starts the timeline. We recommend clearance certificates to deal with the liability. But if you don't do this properly, interest and penalties really rack up, and CRA is a very aggressive creditor. Divorce is one that we see an awful lot. If we don't plan for disparity in assets, we don't plan for an orderly breakdown, or an orderly breakup rather, after the breakdown. This can be incredibly expensive, and I'm sure everybody has a friend who went through a divorce and ended up, everybody has that friend that you maybe jokingly call Mr. or Mrs. Decimals because they've been divorced so many times, they're worth a fraction of what they were before. And these are things that, can we plan 100% against it? Can we say if you get divorced and plan ahead, you're going to lose $0? Absolutely not. But the difference here may be, giving up 5 to 10% of your net worth in maintenance and support payments and growth on certain assets to 50+%, depending on each situation. So these are things you need to be considering. Underinsurance is a huge issue, and Pam and Kelly can talk about that in great detail. Insolvency, obviously, businesses aren't planned properly, guarantees are made that maybe shouldn't have been made, or even when they should have been made, you just hit tough economic times, and these are things that we need to be, very cognizant of. And then obviously, as the last few slides have gone over in great detail, business succession, business dispute issues are a great way to erode wealth, not just on the loss of business, loss of future business, but the cost of litigation and the cost of repair can be quite substantial.
And I think as we have as a low potential, a lot of people, truly sometimes think, well, why would I invest in the markets when, I can get 30 cents on my dollar for my business if I just keep reinvesting in my business. But that's the thing, is all of a sudden you could run up against COVID and you've reinvested in your business to the point where you have no available cash, which you've seen with a lot of businesses are just clamoring to get back to work. You want to have available cash to you. You always want to have that 6 months worth of revenues just sitting there so that should something happen, you can pay your expenses. And really the market correction from all of this, as you've kind of seen, there was a distinct snapback even with this market correction. Is market corrections, when you're investing for the long term, they always correct themselves over time. We had a big correction already, not saying that the markets aren't going to be completely volatile for the next year or two. They probably will be. But what we can say is over the long term, you always make money on the markets. So that's why we say it's really a low level of permanent loss. death, it's kind of, you have to settle the estate. But death is also something to think about when it comes to taxes. A lot of people who have a corporation are surprised to realize is that assets that come out of your company, even the value of your company now, is actually taxable. So, that's a huge wealth eroding event should something happen. But I'll get Kelly to talk a little bit more about injury or death, underinsured illness, because that's a big thing when he gets into those details that the banks watch. So if you have a line of credit and all of a sudden you get cancer and you're not around your business much anymore, the banks watch that really, really, really close. And they always, especially if they lend you money, they'll drop in once in a while to see how things are going, or just to shoot the shit kind of thing over what's happening. And really what they're doing is evaluating where your business is at, what's going on. They have the business people that watch that. And if all of a sudden you're missing from your business quite a bit and someone says, wow, he's got a really serious cancer, all of a sudden, or things aren't going so well like COVID, or things aren't going so well with oil and gas. You hear that right now where all of a sudden the banks start doing what's called pulling the line of credits, or saying you can no longer have your loan, you owe us X immediately. They can do that, and they do it a lot. And they can sell off assets, and if they can, take a couple drill rigs off of you and sell them to someone like Shell, they're going to do that and pull back as much money as they can get off of some of the stuff to recover their loan losses. Because anytime that they think they're going to lose money, they'll swoop in and make sure that they don't lose as much as you do. So that's something, and again, I'll get Kelly to talk about how we insure illness and things like that.
Well, thanks, Pam. I think wealth creation is more talked about. It's more exciting. It's growth strategy, and maybe that's where the business ownership leads that topic and that focus. But wealth preservation is equally, if not more important than that. So I always like that analogy where if we're building your business together and we're helping you support that, we want to build the foundation of a skyscraper so that regardless of how tall you or big or significant you grow the business, whether it's 10 stories or 100 stories, you've got that rock solid foundation. And that's not just a one-time exercise or conversation. It happens over time. So it's almost like we can put into place a month a year or 2 months of the year where we really focus on that. We help you work on the business. We help you focus on risk management, which is otherwise known as wealth preservation. So the best way to understand that too is if we're managing against risks, we really have to dive into what those risks are. A lot of those are represented on this page, but we can help you with our pool of experience and what we've seen in other businesses, what could relate to you and how those scenarios exist. To use one as an example, underinsured illness or injury, a lot of people don't really see where that could impact them. And there's countless stories of skiing with family and hitting your head against a tree, never mind the typical car crash or hit by a bus scenario. There's a lot of those situations where you might not properly value the impact to the company that you've had, or from a key person angle or a buy-sell, buyout provisions if a partner becomes disabled. So it's really key, almost as that annual meeting, that we can kind of dive in to the wealth preservation side as you're focused on growth strategy. And as an annual meeting, we can work through the numbers and help you recalculate that almost on an annual basis to make sure that your protection strategies keep current with the pace of your continued growth of the business.
And I think it's really important to consider, like a lot of people, your business is there for you. So you want to definitely make sure that if your business is there for you, you want to make sure that you're covering off those liabilities. So you have critical illness insurance, you have disability insurance, because, if you're really sick for a long period of time, your partner might need some help and might say, like, I can't do this forever. And of course, that's one of the provisions in your USA that you might want to decide is, if someone gets sick, how long would you want to wait for them? And some people might say forever, and other people say, what's reasonable is probably 2 or 3 years, that then it would trigger a buyout. And if you've got no money, or something like COVID happens and your partner's now got cancer for the second year, and you go, wow, I can't pay them out because you haven't funded your buy-sell agreement, this stuff is, cents on the dollar when it works out to it. It's cheap, and it's cheap for what you're going to get out of it. And you always have that preparation to actually be able to get out of it should something happen, or even look after yourself should something happen, and be able to look after the business. There's even, overhead coverage for business expenses. Is that, even right now, you could actually get full overhead coverage for COVID if you actually were sick with COVID, and it would fully pay for all your business expenses while you're off. So that's huge. And we've had a lot of physicians even asking, am I covered? Am I covered with my disability and my buyout for my clinic? And of course you are.
And Pam, I would go so far as to say that managing these risks is through a contingency plan for those scenarios that we can help you prepare and contract for, which sometimes includes the use of insurance, which partially pays for that. And it's not to be viewed as a cost, but more as an investment in what is usually the business owner's largest asset, which is the equity in that enterprise. So, and these things, if there's insurance factoring into these contingency plans, it's not just an outlay of cost. You can a lot of times have a return of those costs or have cash value represented in that, because the best practice with this is to reduce reliance on outside financing or outside banks. And there are ways and methods that you can finance yourself and embrace more freedom and choice to have the flexibility in that business operation. But the key message here too, that we'll repeat even a few more times today, is that this cannot be completed in the face of the actual emergency. We have to do it in advance of that so that we're covered before. Otherwise, we're left kind of, with your hands in your pockets or your hands in the air without actual action that you can take when that emergency occurs if we haven't thought about it. All right, let's move on.
So there's multiple different personal protection strategies out there that we may employ, and they're largely fact specific and risk specific. And so we've listed here some of the primary ones that tend to come up a lot. So I mean, one of the things we want to consider here, and I'll let Pam and Kelly talk about some of these as well. I'm going to focus on the private corporation shares and the use of trust planning here. One of the things that we can do often to try to mitigate risk and to try to move value around is the use of a trust, whether it's a spousal trust for the benefit of the spouse during their life and beneficiaries after, or a family trust that may take on shares, and it's a very effective tool for succession while creating a new taxpayer and creating new ownership that takes it outside of your asset base. Wasting freezes are very common, very useful for succession between generations, because they allow the primary shareholder, mom or dad, or both, depending on the corporation, family business, to stay with the family to be able to manage the business and to really be able to oversee the succession. They convert their common shares into preferred shares, and why we call it wasting is that the preferred shares are wasted away, as in they're redeemed over time, and that may depend on the nature of the business. It may be a required period of time. It may be as soon as the successors can do this. One of the things we can also do to help with these is we may keep voting value with these shares, or we may have a separate class of non-participating, as in no value, no dividends, shares, to allow mom or dad to continue to control the business, to continue to be the face of the business, and to be able to guide the next generation into proper business management. This protects on a few different levels. It protects the business from collapse because it helps having the steady hand in many cases where mom and dad or whoever is the face of the business. The clients want to see mom or dad whenever they come into the office. That can be protected, that can be integrated over time, and that reduces that risk of loss on succession. Having a separate taxpayer holding the growth shares, the future of the company, well, now we have that potential for the children to not necessarily hold this directly. It may not be family property for the purposes of divorce because it's held by a family trust and there's multiple shareholders or beneficiaries who could be the shareholders. One of the important things here is the use of an independent trustee. Does this have to be me, Kelly, or Pam? No, it can be a family friend. It can be a trust company. It really depends on the situation, but it should be somebody who deals at arm's length from the corporation and arm's length from the family so that they can be seen to make independent decisions. This will prevent a lot of the issues to say it's not truly a discretionary trust. It's the tool of the person who controls the trust, and then it can get dragged into some issues. So when we do these sorts of structures, they add a lot of certainty. And when you have a trust involved and you build a trust, you can also help set the rules of it and how the trustees govern it for the future. And this provides an element of control while also providing an element of flexibility for future events as well. A lot of things make sense to do when you have spouses in different risk profiles. If you have a spouse that's active in a business with a high litigation risk versus one who doesn't, perhaps you roll shares over between those spouses and be able to have ownership and risk between one of those two spouses. And that's very fact specific, but very effective in the right circumstances.
And of course, in the sense of, you know, and I'll let Kelly talk about the real property and some of the guarantees and mortgages. But for RSPs, we often say to people, like, obviously a really big personal protection strategy we often employ with a lot of business owners, especially ones that are, you know, in a litigious situation, which, you know, a lot of business owners can be at some point in time, is we offer something called seg funds. So segregated funds are funds that are actually segregated from the assets of the company is how they're designed, but they're actually an insurance product. So what they do is they provide you with guarantees on your money, but they also provide you some creditor protection. So that should someone come after the company, those assets in your RSPs are completely protected. Whereas if you had ETFs or banks or, you know, stocks and stuff outside, those are not protected from guarantors. So, and from creditors, I mean. So, that's really important for a lot of business owners. And we often say if you're going to be facing that kind of situation, you can't do it if all of a sudden it's like, okay, I've gotten delivered a lawsuit here in my hands. It's now been given to me and now I'm going to move all my assets into segregated funds. Usually the courts will say, well, no, because you're doing that in anticipation of a court proceeding, and they won't allow it. But if you've actually planned ahead of time, that's where you can protect those assets away. IPPs, which has become a really common thing now to start looking at for a lot of business owners, because of course with the new tax rules, you can't income split with spouses anymore like you used to be able to, especially with professional corporations. IPPs become really important in the fact that you can plan for your own retirement far and above what you could prior just to your RSP. So you can go way above your limit. It's a calculation that you can do from previous years. And you may be able to put lots of corporate assets and have it as a deduction to your corporation that you can actually put away for yourself, but not to mention you can actually set it up as well if your wife's part of the company or if she's a shareholder of the company. You can have her on that, and then it becomes a way of income splitting and having that money to them as well. Or of course, like we say, life insurance, we often say businesses grow over time, and we really love the investment type insurance where basically you can get into an investment product insurance like a 20 pay or something that's, you know, a 10 pay a lot of business owners can afford to do, where basically you're putting away assets in your business in a life insurance plan. It also defeats the new rules around having too much cash in your business that basically now can be taxed, also under the new tax rules. That actually completely avoids it. So you can actually put lots of money into those, and they've been exempted from that rule. So it's like all of a sudden, if we're now going to be taxable above $50,000, we may want to throw that into some insurance, allow it to grow it tax-free inside the policy, grow it tax-free inside the business, and then use it for a retirement strategy outside within the business, or even use it just as an estate plan within the business, because all businesses grow over time. And what you might think your business needs right now for insurance is going to grow. That way, if you start off early with those, they tend to grow along with your business. And if they don't, we can always add to it, or we can decrease it if we don't need as much. And we can look at increasing the cash value and modifying those policies as you kind of need it to happen. And so those become fantastic strategies to actually not only have for cash. A lot of people don't know the story about Walt Disney, but Walt Disney wouldn't be Walt Disney today if they actually didn't have a cash value policy. Matt's smiling, so he knows the story. But they actually ran out of money, and they had problems with debtors, and they had problems with the banks, and all of a sudden it's like the only cash asset he had was a huge life insurance policy, and he used the cash value inside the policy to actually fund everything that he needed to do and fund back the banks. It actually saved his business, and he's one that, you know, wrote about it in a big book. I looked off to the side here, I have the big book of Walt Disney. He tells a big story about it, and it's pretty amazing when you think about, even for our clients, when they've had cash problems or even during COVID, you've got something that's making you a guaranteed rate of interest, and they're like, wow, you know, I've got a backstop should something happen. I've got cash there that can actually help me get through this period too. If I need extra cash, it's there for me. And that's, you become your own banker. And that's really important.
So just talking about reviewing guarantees and mortgages and real property, a lot of times when a business is initially set up, there's personal guarantees tied to banking connections, and they're an important connection, but there are also choices and options and how that's structured over time as you grow and achieve some measure of financial independence for that corporate entity or your overall corporate structure as it grows. And that's where oftentimes people have a holding company to literally hold some of those assets, where the operating company's job is to really kind of create that cash. So there's tax changes that have affected that in recent years, but in general, some of those concepts still apply. You might, for example, want one spouse in the household to own some of the corporate interests. The other spouse is holding a lot of the personal assets, especially, you know, for example, a mortgage-free house. Doesn't affect matrimonial property if there's ever a divorce, but through proper planning, you just increase the level of your protection. So a lot of what we're talking about here is dotting I's and crossing T's. You don't need to know everything that we've discussed or even how it applies. I think if some of that is merited any interest and might be applicable to you, that's where we can walk you through a bit of a second opinion analysis and help you understand what that executive summary looks like to you and how these concepts can apply to you. We find not many planners go to the level of depth and comprehensiveness that we do, where we're talking about the 3 to 5 year plan and then the 10-year plan plus, in terms of these are concepts that we're working on behind the scenes to your benefit. And then we bring that into our ongoing regular meetings throughout the year to kind of keep you apprised of how it affects you and what's coming up next on the runway. Great.
So on the other side of the coin, we've got our corporate protection strategy. So we've got our ideas to protect the individual, but from here, it's what works from a corporate level. Some strategies may be to consider using different corporations, and that may be splitting land and investment assets. If they're already within one corporation, we may what we call butterfly it out, which is a series of reorganizations in order to move the assets in between the two in exchange of shares and notes. It's a somewhat complicated sounding transaction, but effectively at the end of the day, we can bifurcate two assets. The other major thing we can do is, if they aren't already in one corporation, is we consider setting up a different entity for each commercial venture. We may have a rental company operation, and we may have each commercial building or each residential building held by a different company in order to reduce the amount of liability risk if there's an issue between one or the other. We may set up a structure where trust is involved with a corporate beneficiary and be able to play around with dividends on that. I'll let Pam get into a bit more detail on that. The other option sometimes that I haven't listed here is, to look at partnership structures as well, and using ventures properly there.
And of course, with anybody who has investments inside their corporation, um, there's a term called GRIP, which you don't need to know about, but what we try to do is kind of say, what can we take out of the business that benefits the shareholder tax free, that's allowable within that room? You obviously need to know what's called your C-nil balance, which is basically your losses that you've claimed over time. And you can take out a dividend that could pay out to you tax free off your investments. So we do look at that for people who have to pay off certain things personally. And it's like, how can we get this out? Because over time, you usually build that up. And it's not something often that we find the accountants really sit and observe and look at and determine what it is. That's really where we use field law to kind of go through and say, here's what it is. Is there anything that we should be taking out or can take out? You obviously want to make it worth your while. You don't want to, take out small amounts, but if there's bigger amounts that we can do, we've had some physicians who have, purchased almost an entire house off of that investment money, and they've done that tax free. So that becomes a really amazing way to take out money out of your corporation. And we can talk about obviously insurance, like we mentioned before, is having that corporate protection strategy, because of course that money is yours, and it's similar to a seg fund. It's pretty protected underneath a corporation. So when you build up cash inside that, it allows you to do different things. If you wind down the company, you can wind the insurance out. There's various different ways we can move the insurance to another company. There's things that we can do that make a lot of flexibility with insurance as well.
And if you ask us more about some of these concepts, we can show you case studies as to what that looks like. So without proper planning, a lot of times what happens is cash and tax implications and wind down or wind out of some of these assets. But through proper planning, and insurance is one way to fund some of these tax bills, but it's at cents on the dollar. A lot of times we can impact the whole household or the people that you have intended to succeed you after the business or even as a business sale. So a lot of these strategies just require time and conversation and are uniquely tailored to your situation. And we can continue that dialogue when we connect in person.
And of course, an individual pension plan, that's next. Again, we kind of talked about that on the last slide, but a pension plan obviously has a requirement to pay. So over time, you kind of look at what is the calculation. So basically, it's an underwriting calculation that they do that calculates how much a corporation has to pay into the pension each year. So you have an obligation to pay into that pension. So again, it's similar to an RSP asset. So it's kind of protected underneath your company as well. So that becomes a way of building up assets for yourself, for your business and your family that you need to have for later on in retirement. And Matt, you can talk about the last one with securitization of retained earnings.
So with this one, there's a few different ways that we go about doing this. One of the more common ones is, to have a holding co and an operating co take a security interest in property. And the idea with this would be it would be secured in exchange for services or in exchange of a use of a property or something along that nature. And then so it provides a layer of protection for creditors because this holding company holds a security interest that in theory would be ahead in priority. Again, this is kind of a case-by-case, fact-specific strategy. Using intercorporate debt with retained earnings is another strategy that we often use and depends on the financial status of each respective company and what their pools look like, their tax pools, to be able to really maximize this type of planning.
Great, and it should be said that overall, through the comprehensive plan, we're coordinating your individual plan and your personal net worth with your corporate net worth and your corporate protection strategies. So it all blends together and requires the management and coordination and communication amongst that team.
Yeah, and of course, with all the new passive investment rules, never has it become more important to use insurance, to use IPPs, because again, IPPs, skirt that whole passive investment rules as well, where they're allowed, and it's also credit protected, much like a segregated fund. Plus, two, you could hold segregated funds within that IPP as well. So there's some great aspects to that. and some planning around that. But again, it takes an actuary, it takes work from the lawyers and everything else to set that up properly.
Okay.
So does anyone have any questions, or could we, maybe hold your hand up like this? There's a little hand button on the questions. We can actually unmute you and you could ask about your own personal situation if you like, or ask some questions that you have in regards to the estate, and we'll just open it up to you to actually speak on here if you want to. We don't need to see you, but we can unmute you and you could speak about your own situation, or you could ask any questions that you may have.
And you can type in that chat box, but otherwise we thank everybody for attending, and we, especially appreciate, Matt, your help as well.
Yes,
Jeff, do you have any questions lined up for us?
Yes, we do, Kelly. We have a question/comment from Bill. He said, this was very interesting. I now see the importance of planning ahead. What are the next steps?
I think that's a great question. We get that often. I think a lot of people say, well, I know my business really well, but I don't understand exactly how this applies to me. I think that's why we've created our proprietary wealth creation systems, specializing in business owners. And we cumulatively have that process where a lot of times we're addressing the risk management and some of these tax and legal coordination of keeping your plan congruent with your growth strategy. So the answer to the question is, if you're new to us, you can send a quick email to info@thetowergroup.ca, and we have a second opinion process where we can give you a bit of a diagnostic in terms of your current status and see if there's any planning gaps beyond what you're doing well. There are a lot of times issues that haven't been addressed that could be a plan wrecker or a major detriment to continued business growth.
Thanks, Kelly. So at this time, it looks like there's no more questions. Like Kelly mentioned, if anything comes up after the webinar, feel free to email us at info@thetowergroup.ca, and we'll have the video up on YouTube. Don't forget to like and subscribe. I'll pass it on to you, Pam, to finish it off.
Yes, thanks again, everybody, for attending. We always appreciate all of your time watching our webinars, and hopefully this has led you in the right direction that you could actually start this process. So we look forward to seeing you in our offices in the boardroom to discuss this. Thanks so much. Thanks again, Matt. Thanks again, Kelly.
Thanks for having me.